Hi, Matthew.
Hi, Mark.
Looking very smart there.
I think we're broadcasting, Mark, so don't say anything rude.
No, I saw the recording button in the corner.
Everyone else has been wearing a suit.
Oh, I'm a casual silk.
Well, I know. I didn't know either. So I had to put mine on hastily this morning. Do you
All
want to?
right. It is. Oh, let's.
Yeah, that's fine. We don't mind.
No.
Somebody's just put on, we can hear you. I know. Right, go on, Mark.
It's all the banter.
Go first, or are you going first?
I'm going first, I think. Do you want me to? Is that okay?
Yeah.
Is everybody on? Is everybody back on?
They're coming back on.
Yeah. Give it a few more. Do you want me to monitor the question and answer thing while you're doing yours?
Yeah.
Is that 96 we've got?
I think you might. Yeah, I think you might as well just do it because it's more or less. Yeah.
Right.
Look, someone says, "Nice to see a casual silk. Seems like a rarity."
Yes, I thought I'd go for that. I'm going for that look today, casual silk.
Hello. Look, got a bit of a Morrissey haircut going on there, Mark.
I know. It's called a midlife crisis, which happens to new young silks, I'm afraid. But I thought I'd give this. I've always been impressed by the London silk look, which seems to be this sort of dressed down approach. But it's not going to alter what I've got to say to you all today, and that's basically giving you an introduction into the work of the Business and Property Department. And Business and Property Department, it's a new name for us. Basically, it comprises the department which carries out the work which was previously done in the Chancery Division, the Mercantile Division, the Technology and Construction Court, and also the Commercial Court in London. So new name, same work. When I first came to the bar, I had no idea what work I wanted to do. I just knew I wanted to be a barrister and I wanted to see the different levels of work. I quite enjoyed company law at university and land law, and King's Chambers pointed me in the direction of this type of work, and I've never looked back. Right, let's start by giving you a flavour of what our department is. Apologies, I'm looking to the left. I've got my notes to the left of me here. We have 7 QCs in our department now, and we have junior counsel, which runs down every level of call, down to our newest tenant, Nick Taylor, who completed his pupillage this year. Most of the members of Chambers, like Matthew and myself, did our pupillage in Chambers. We've then applied for tenancy, taken tenancy, and then stayed with Chambers to develop our practices. The competition that we have for work is primarily not the local bar. There's one set of Chambers, Exchange, who provide a lot of our competition, but for most part we're competing with national sets and going up against the best that London has to offer. So the first thing to bear in mind is, if you're considering a career at the Business and Property Bar, if you're coming to a Chambers like ourselves, there is going to be no dilution in the level of work that you're going to see, save for this. We're not obviously going to be able to compete with the shipping work, which is the part of the London bars, key sets like your Brick Courts, but for the rest of it, we're offering a similar staple. Everybody always thinks that a career at the Business and Property Bar, you're going to be stuck behind a desk doing papers. Well, yes, there is a lot of paperwork, but we're finding it's paperwork at the outset, which is in the context of devising strategies for your solicitors as to how to put the case in its best form prior to the commencement of proceedings. The pre-action stage is becoming very important now. Parties want to try and settle cases before they get into the vagaries of the court system. So there is a lot of paperwork, but there's also an incredible amount of advocacy. We do trials. We do plenty of trial advocacy, interim applications. At one extreme, you've got case management, where you're going before a judge and arguing over the directions which should apply to the progress of the case. Things like applications for summary judgment, where you're saying this case doesn't need to go to trial. I can show you it's going to succeed or fail now. Security for costs, injunctions. There is a huge amount of advocacy work there to do at the Business and Property Bar. So please do not think that if you come into the Business and Property Bar, you're not going to get as much advocacy as you would in other areas. I'm finding our juniors are doing equally as much advocacy as the Common Law Department. just want to give you a flavour as to the type of work which is included in business and property, because when we say it's company, it's property, it sounds quite dry. But I just want to give you some examples by reference to my week. This week is what I've been doing. Monday was an application for case for 2 days, asking a judge to commit somebody to prison for the breach of what you'll have heard in the news is called super injunctions. We'd obtained a super injunction preventing this person from making some false but salacious allegations against his former business partner. We got an injunction which stopped him doing that. We defended it all the way up to the Court of Appeal successfully. And then this, quotes, idiot, close quotes, has gone out into the market and started making these allegations. So we were having a 2-day hearing to consider whether or not he should go to prison for that. Yesterday was doing a £2 million mediation dispute between a recruitment company and one of its clients over liability for termination fees. Now that sounds straightforward, but the issues which were raised in the case were whether or not the termination fee clauses were penalty clauses, whether or not an estoppel had arisen preventing us from exercising our rights, the operation of entire agreement clauses, so a whole host of issues. Other things that we've done, we do a lot of restraint of trade work, and you'll have seen some of our high profile cases as a Chambers, including myself and Paul Chasty. We worked on the Wayne Rooney case, which one of the leading cases on a restraint of trade, and that fell within the business and property jurisdiction. His agents were trying to hold him to a 7-year agency agreement when the usual agreement was 2 years. And we were able to argue that that was a restraint of trade. Same with Bradley Wiggins, agency contracts. We're arguing restraint of trade, again, successful on that. So there's a whole host of work within the headings of company law, contract law, real property law. If you're asking yourself the question as to whether or not the business and property law is for you, and Matthew will give his slant on this, is I think you've got to really be at university having an interest in your contract subjects, your company, your property. They're the areas. If you're interested in them, then it's worth you looking at pursuing a career at the business and property bar. I'll be around to answer some questions, and I'll hand over to Matthew now.
Hi everyone. Right, I was going to put some slides up actually, so I might have a fiddle with that for a second, if you just excuse me. Right, here we are. Okay, so well, that's just the first one. So the sort of work I do within the business and property section revolves around property, and in particular land and the transmission of land between living people and through wills and passing down through the generations like that. Now that's sometimes called a chancery barrister, which is a bit of an old-fashioned sounding job title. And right, wait a minute, I'm trying to shift my excuse me 1 second, I'm having more technical issues here. Trying to move forward on my slide. It's not working. I'll be really upset if I can't do them. I've spent ages doing. Wait a second, everyone.
Have you got your right arrow key?
Second, while I have a fiddle, and then I'll promise I'll just get on with it. I'm pressing every button on the keyboard now. Oh, that's no good, is it?
Your microphone seems to be.
Yeah, right, okay. I think, oh dear. Right, okay, never mind. I think John Hunter had the same problem this morning. Right, we'll have to look into that. So the courts, the chancery courts, where that name comes from is the old-fashioned chancellor's court, which, if you think about it, land is probably the most important, was historically probably the most important part of everyone's, the whole economy. So land law tended to be one of the most important things to be dealt with, and it was dealt with by what used to be called the chancellor. So that became chancery work, and there was a special chancery court. Now that court basically now is in what's called the Rolls Building in London, a brand new modern office building, court building, fabulous building. I was going to show you a picture of it, but I can't. And in fact, it houses all of the business and property courts in London. And I was reading the Chancery Guide, which says it's the largest specialist centre for financial, business and property litigation in the world. So it's a big part of our economy, and some of the cases that you get being dealt with there are enormous. There's no, and huge amounts of money being dealt with. Our court in Manchester, we've also got a fabulous modern civil justice centre here. And as Mark was saying, some really, really good big stakes financial work you can do up here as well. Now, as I said earlier on this morning, any barrister who you ask will say that if someone asks you at a party, what do you do? And you say, I'm a barrister. That person always then assumes that you're a criminal barrister. And as I said, when you say, I do property work, you do get the sense that they lose interest a bit. Now, the fact is, I think that it just as with a criminal barrister's criminal client, our clients can be just as colourful. The story of the case can be just as much of a whodunit as any criminal trial. And whilst your client is not normally facing prison unless you do really badly for them, or in the case of Mark's committal application, because sometimes things do get to that stage in civil work. So although they're not normally facing prison, quite often the difference between winning or losing your case can be your client's house, it could be their business, their fortune, or indeed their reputation. And so every case, one of the greatest things about being a barrister is right from the word go, every case that you do, even if it's the smallest case that Chambers has ever dealt with in terms of money or overall value, for that client who you are directly responsible for, it's the most important thing imaginable. And you're there to put that person's case for them. And that happens right from an early stage in our chambers. One of the big draws of becoming a barrister, for me anyway, was just having that responsibility straight away. If you went into a big solicitor's firm, which some of you might be thinking of, it's a great career, but you will not get that direct responsibility and contact with clients from the word go. So what sort of disputes are there even just in the property context? There are so many different types of people that can fall out with one another. So you can expect to deal with disputes between landlords and their tenants, between banks and borrowers, between relatives of somebody who's just died, arguing about the estate, come on to that in a minute, between neighbours, not just domestic neighbours, which is quite often what I do, is a boundary dispute between neighbours who hate each other, and boy, do they really hate each other sometimes, but just also between large commercial neighbours. I've got a case at the moment involving the Manchester Ship Canal and the drainage of water into that. So even just taking one of those categories, though, they all fall down into various subcategories. There's all sorts of different clients within them. If you take landlords and tenants, for example, your client might be a massive international organisation fighting a case against a big commercial landlord. If you want an example of that, have a look at the recent case of the European Medicines Agency. What happened there was that and this is just to take a really good example, when Brexit happened, the European Medicines Agency, which is an arm of the European Union, decided that it would try to get out of its 10-year lease of a whole building in Canary Wharf. The rent was £10 million a year, and it had about 23 years of its lease left to run. So the value is enormous. And as it happened, the judge didn't agree that Brexit really had anything to do with the lease. They were trying to argue that the lease was subject to what's called frustration, which is a doctrine whereby a supervening event can put an end to a contract. Judge held that Brexit wasn't a frustrating event. Of course, it can be for a lot of us, but not in that sense anyway. But just on the other end of the scale with landlords and tenants, you could be acting for somebody who's just been evicted from their little flat. The landlord could come around. I've done these cases, especially when I was very junior. Throws the tenants out on the street, puts all their stuff in bin bags, gives them a bit of a smack at the same time, and you can be suing the landlord for damages, or even more importantly, sometimes going to court on an emergency basis to get an injunction to get that person back into their flat, so to get the judge to order the landlord to let them do that. And so, is it just people falling out about money? No, it isn't. In my experience, quite often the motivation is all the things that make up a good film script: love, jealousy, status, revenge, all of these impulses that cause us to fall out with one another. And this is where my slides would have come in really good. But anyway, I don't know if any of you have seen the film Knives Out. Have you seen that, Mark? Yeah.
Yeah.
So in that film, I just thought it just reminded me of some of the work that I do. The Wealthy Patriot, it's a sort of modern, slightly Agatha Christie-esque thing with that guy that was James Bond in, and Christopher Plummer plays Harlan Thrombey, who is the wealthy patriarch found dead in his big Connecticut mansion, changed his will, puts everyone in his family right out. Turns out, I think, that he's left everything. Well, I better not do a spoiler, but there is a dramatic scene, which is the reading of the will, when everything emerges. Now, here's a fact for you. And I'm telling you this because I do quite a lot of wills and probate work, and a wills trial is generally probably the best trials that you get to do in my experience. But here's a fact for you. There's generally no such thing as the reading of a will in real life. So after the reading of the will in the film, the family confront their lawyer. They're urging him to find any way possible to challenge the will, which they don't like. And here's another fact for you. That does happen in real life. It happens to me when somebody writes a will that my client doesn't like. And they come in and see me and say, well, it can't be. My dad never wanted that. He would never have treated me in this way. It must be a way of getting out of it. So I have to consider all of the options there. You have to consider, for example, could there be said to have been undue influence exercised over the person who wrote the will, which is pressure being brought to bear by somebody in a way which overbears the freedom of choice. Could it be said that there was lack of capacity? And there's a very well-known test for capacity for making a will, which you have to apply. It's called the test in Banks and Goodfellow, which is in itself a fascinating case from the 1860s. I've actually done talks to solicitors just on that case. It's really interesting. So that's the test you apply. Forgery, what about that? Could it have been that the will was forged? Sometimes in these cases you get, and indeed in many commercial cases, you'd be surprised at how many people still try and forge document, and how it can make it can win or lose you a whole case, just proving that one signature wasn't by the person who's said it's by. So as I say, you can get handwriting evidence on that. And what one case I did, we had loads of handwriting evidence on this signature. And they always argue, look at the curve of the A. there, and look at this dot of the over the I. And then it turned out that the ink that this signature was comprised of hadn't been manufactured until 5 years after the alleged date of the signature. So it shows what all this how useful all that speculation was. And what about other things? I'm just giving you examples of the things you have to think of. Fraudulent calumny. So that's a legal doctrine whereby you can challenge a will if the person who wrote it has had lies told to him or her, which have influenced the choice and possibly caused the will maker to exclude somebody. And what about a challenge under the Inheritance Act? Because you don't have to set aside the will. You could say, well, this will doesn't make reasonable financial provision, and the courts are given power to alter the terms of the will, or even change them completely if somebody has been left without reasonable financial provision. Those acts came in the early 20th century, of course, to stop, normally to protect, in those days, wives from the temptations of their husband to leave everything to somebody other than her, and to put her in the workhouse. So all of these things have to be considered. One of the most exciting cases I've ever done was a wills case, where a man unfortunately suffered from long-term problems with alcohol. He made his will, I think, 25 minutes before he died, in a hospital room, waiting to go in for some treatment, in bed in hospital. And the estate was worth £5 or £6 million, and he left it to his girlfriend and excluded his wife and his children. And so, you know, you couldn't write a script that's more likely to give rise to trouble. And it's a very sad case, but it was a very, very interesting case, and it fought for 2 weeks. And your job is to try and elicit the facts from your client. To try and, I mean, you can't obviously you have to just go on what they tell you. You can't tell them what to say, but you have to try and draw out the relevant facts to see if those facts that you can prove together amount to the correct legal ingredients for one of those things like undue influence or lack of capacity that I've mentioned. And one of the things that does make the job quite different from the job of a criminal barrister is that whereas in a criminal trial there will be a lot of argument about the facts, it all revolves around who did what when. In our cases, there's quite often a lot of argument about what the law is before you even get to the facts. So sometimes you have to prepare a case on sort of thinking about different ways that the judge might decide what the law even says in the first place. So just finally, if I could, before I perhaps hand over back to Mark for a minute, if you're thinking about a life at the bar, what type of person do you think you might have to be? Well, with me, it was no problem, because my parents always told me that I could make a good living out of arguing with people. And I think joking aside, it's true that if you like having a debate, having an argument, and you like marshalling facts, and you like meeting people and using their problems, using the law to solve their problems, I think that it's a brilliant career to go into. And then why business and property? Why that over any of the other things? Well, I would say probably for us, we probably more than other areas get involved in the more difficult areas of law. So particularly land law is quite technical. I'm still learning now. I've been doing it for 20 years. I still come across things that take me by surprise in the books and the cases. So if you're interested in the law itself, I think it's good. Really, I think to some extent it can be a bit more of an intellectual challenge than perhaps a business skill that you might need. So I don't know what you think about that, Mark.
I think that sums it up perfectly as to the type of person you should be. And I think in particular, if you think, one, not just debating, but you enjoy, in effect, getting stuck into something, finding out facts, assimilating facts. The skill of cross-examination is one of the great delights of this job. And if you're somebody who likes formulating arguments, formulating strategies, formulating questions to put forward, I think it's the career for you. We've got a lot of questions, so I'm going to whiz through these in no particular order, but I'm going to start with Kelly at the bottom because she asked first. And Kelly's asking, are you noticing an impact on the nature of cases from COVID? Two layers to that question. One, work is as busy as ever. Whilst we're not having the bank recovery claims at the moment, because obviously there's a moratorium on those, we seem to be having an increase in business-to-business disputes, and also disputes as between companies where you've got shareholders who aren't getting on. You tend to find when the market gets difficult, as COVID has caused it, what were already, say, fragile relationships in companies begin to deteriorate. So we are seeing a real increase in work. And the expectation is that once the moratorium's over, we're going to see an even bigger increase in work with relisted possession claims, bank claims, but most importantly, applications under the new insolvency regulations. Just working up to Mina. Have you ever found it difficult formulating arguments for clients whose cases are more lengthy? The length of the case doesn't really link in with the complexity of the case. What you often find is you have to argue your client's case without fear or favour. Sometimes there'll be those cases where you suddenly think, in particular after a client's given evidence, that basically it's very difficult for you to be able to say anything having their evidence. And sometimes the real skill of the advocate is recognising when, I'm sorry, my lord, I can't say anything further to that. Sam,
you get very, very in my work in particular, you get people, you get disputes where the kind of beginning of the disputes started at right 40 years ago when somebody was, you know, a young person, particularly in family property matters. You know, you get the witness statements and it goes right back to how, oh, I had a row with my sister on her wedding day. She was horrible to me. And so I think to be fair, I think it probably can make it a bit more difficult sometimes if there's a massive history that they expect you to know everything about it as well.
Just answer Martin's question. What's the difference between corporate and commercial law? Corporate law is anything to do with the internal workings and dealings of companies. Commercial law is basically any issues arising out of contractual law. For instance, you get things like disputes over contracts, agency, bailment, those types of things. I'm whizzing through these. I'm trying to answer as many as I can. Does tax law come under business? It would do. We have, I think, just door tenants who practice tax law, and they're based in London. We don't have anybody as a full-time member who does tax law. It's so specialist, you can't do anything else. It's if you're going to do tax law, you have to specialise completely in that. Matthew, can you answer Stephen's questions about the possession claims?
Well, where I can't find it.
Where are possession claims heard? The CPR says they don't fall under the business and property chamber, at least in county courts anyway. So at the very top.
Yeah, so right, nearly all possession claims are heard in the county court. And so if you look at the business and property practice direction, I think you're right from recollection that it doesn't include normal possession actions. So, but they will be just in the local county court, just not in the business and property list. And a possession action normally has to be brought or can be transferred by right to the, particularly if it's against an individual, into the district where the property is situated. when you're in the county court, it normally doesn't really make much difference whether it's listed as a business and property matter or a normal matter.
Ella's just asking this: what advice would you give to a student looking to go into wills and probate? What kind of work experience would be useful? I would say the best work experience to get there, going to wills and probate, I would go and spend a week with a traditional solicitor who is still doing private client work. And I did this when I was in my year out before university, and I worked for a trust and probate lawyer. And I learned so much he handed me a file and just said, read it from page 1 to the back. And you see a lot of the issues and the processes, because when you become a barrister, like Matthew specialised in these disputes, understanding the processes involved is fundamental to your ability to be able to understand the case and get to grips with the issues. Would you add anything?
I agree with that. In fact, I've often thought that I might quite like to take 6 weeks off and go and work in a probate office. Because it's all very, sometimes as well, we get asked to advise on solicitors' negligence. So I'll be asked to advise about whether a solicitor's been negligent when he's been doing conveyancing.
Yeah.
And I've, of course, never done a conveyance in my life. So, you feel like a bit of a know-all, writing your, oh, well, you got this wrong. You didn't do that form right.
I think that's invaluable advice, actually, from Matthew. When I did recruitment, we always get people saying that they want to be a barrister. And one of the questions is, well, how do you know you don't want to be a solicitor? And that's why I'd always recommend that you get experience of both, not just a city firm solicitor or a big firm solicitor. Go and see a small practice as well. Compare the different work. So at least if it's an interview, you can say that you've made an informed decision. I think Milan's the last question we've got to ask is, how does your work overlap with the construction bar? In our chambers, members of the business and property team also do construction work. We have Andrew Singer QC, Kelly Pennifer, Jonathan Ward, who particularly specialise in that area, and they do work in the technology and construction court. And what's quite good now is with the technology and construction court, it's not just limited to traditional construction work. We're seeing a lot of software disputes and that type of technological disputes. So that really does encompass our work. I'm sorry for this whistle stop too. I won't try and cover everybody. Sam's asking, Matthew, if you can give the name, send out the name for the EU Med.
I think I tried to. Oh God, I've not done that right either. The film is Knives Out.
It's excellent.
The case is called, I think, European Medicines Agency against Canary Wharf Management, I think.
Yeah. And would competition cases fall into the business and property area? We have a member in Leeds, Adam Aldred, who's a former solicitor partner at Addleshaws. He does a lot of competition work, and that's an area of our practice that we're looking to take on. We're actually considering whether or not we should take a pupil on in that area. And can you recommend how to gain commercial experience, especially when many chambers are offering mini pupilages right now? I would repeat, if you can't get into a chambers to do it, a lot of the big accountancy firms, solicitor firms are offering remote work experience. And again, that's invaluable for the reasons that Matthew gave. Do you want to answer this one, Matthew? Is there a good life balance in business and property work?
Well, you know what? Being a barrister is one of the best jobs you can do in terms of work-life balance, because you can, to some extent at least, probably after the first few years, you can kind of make a bit of a choice yourself about how hard you want to work. So, I mean, I work very hard, but compared to other members of chambers, some of them work extremely hard. And then there are some people who, that you can make arrangements to work part-time and things. It's one of the advantages of not having a boss.
Yeah.
Now, the disadvantage of being self-employed, there are a number of those, no pension, but I think the main disadvantage of it is it's very unpredictable. So you can be quite relaxed at work, just sort of, I've got a few sets of papers to do. And then all of a sudden, bang, the clerks come, right, you're in London on Monday, you've got a 4-day trial, here's the papers, and they're like this. And that's it, there's your weekend gone. You can't really say no. Well, you can, but not in the junior years, probably. Mark, what do you...
I'm just answering Sidra's question. Or are all barristers self-employed? Most are, but there are a number of employed barristers, and there's actually a specific association, the Employed Barristers Association. the sexy subject's coming next. I think Steve Flynn's, is he doing
Yeah,
sports
this is
law?
the one they all want to hear about, isn't it?
Yeah, so we'll hand over to him. Thank you so much for listening.
Here's the head
Apologies,
of
I
the
didn't wear a
bill.
jacket and tie. I thought I'd adopt the casual look, but thank you very much.
Well, I was just thinking about the idea of taking time off, and one of the things great benefits of being at the bar was I got to take 6 weeks off to go and watch the British Lions one summer. So there are some great benefits that you can't get if you're a solicitor. So that was one of the things I was going to echo from what Matthew was saying a few moments ago.
I'm just going to reply to those
Okay,
very kind
great.
messages from everybody.
Okay.
Okay,
Steve,
speak
over
to you
to
soon.
you.
Enjoy.
Okay.
Bye.